Okay, so we have it recorded here. I'll ask everyone to just put it on mute if you don't mind. And again, welcome to tonight's estate planning webinar here with estate planning attorney Giovanni Borges in itself. So, Attorney Borges, thank you for joining us tonight. I think you're on mute. There you go.
Yes. Thank you for the kind words, always, Sherwin. I appreciate it. I'm not sure if we have anyone here that's attended the past. I think we've actually been doing this for 3 years. This might be year number 4 doing this.
You're
So
right. Yeah.
if you've attended before, I apologize for being a little repetitive and probably using the same examples I've used the past 3 years, but it works. And thank you guys for attending tonight. It's 8 o'clock on a weekday. Who wants to be on a computer, listening to information about estate planning at 8 o'clock on a weekday? It's not super exciting, but it's important because this is a topic that applies to anybody. It doesn't matter how much money you make, what career you work with, what family structure you have. Estate planning applies to everybody. It's different circumstances depending on each person. So the fact that you're here tonight at 8 o'clock on a weekday, investing in your education and in yourself and in your family and your assets, that's a great thing. And you should be proud of yourself for attending tonight's event. So thank you for that. I told Sherwin, I don't want to lecture here for 45 minutes or an hour where I'm just kind of reading to myself and it's complete silence and just explaining things to you. So I do want this to be somewhat interactive. So as I go, if anyone has any questions, feel free just to unmute yourself, ask me the question, or if you want to put a question in the chat. And I like it to be a little interactive. I think it'll be a little more beneficial for everybody. It'll help us kind of facilitate the conversation and the topic. So if at any point, if you have any questions, feel free to ask them. There's no such thing as a stupid question. We're all here to learn together and to better ourselves and essentially to protect our assets and everything that you work hard for. So that's what estate planning is essentially. Just a little background here. I've been an attorney for about 4 years. Before that, I was a law clerk for 3 years while I was in law school. So I was pretty much doing the same stuff that attorneys did, but I just hadn't passed the bar yet because I was in law school. And before that, I was a paralegal for 5 years. And before that, I graduated from UCF with a bachelor's of science in legal studies, a minor in business administration, a certificate in public and professional writing. I graduated from Nova Law. When I graduated from law school, I was involved. I was president of a couple chapters there. I received the Dean's List certificate many times for having elite, academic characteristics or certain scores on certain classes. I received several book rewards for having the highest grade in the class. So I'm not saying this to be pompous or to be arrogant. I know I can look young, and a lot of times I get this all the time. Hey, you look super young. What are you going to teach me? So I just want you to understand that, I take law serious. I've studied this for many years. Even though I've only been practicing lawyer for 4 years, I have many years of experience as a paralegal, as a law clerk, doing all of this prior to being an attorney. So I like to think that I have more than 10, 11 years of really doing all the stuff that I'm going to explain tonight. So with that said, does anybody know what a probate is? Okay, I'm going to take that as a no. If anyone wants to interrupt me, please go on ahead or just put something in the chat. So a probate is an administration that goes through the court after someone's passed away. And essentially what happens is the family, one of the family members or someone that inherits something through the law or through a last will and testament, that person has to go before the judge or hire an attorney, file some paperwork with the court and say, for example, Giovanni Borges passed away on this day. He was survived by a spouse or survived by 2 children. And here are the assets that he had. He had maybe a car, a house, and a bank account with $1,000 in it. So when probate goes on, when someone passes away, what they own, their assets, a car, a house, money, all of that doesn't just instantly transfer to an heir or beneficiary. And if you want to write this part down, most judges don't even know this. This is great info. An heir is someone that inherits some type of asset from someone else under the Florida law. So Florida law, what's called intestate, when someone dies without a last will and testament, Florida law says or has like kind of a chart in terms of who inherits what. So for example, if I passed away and I had no children, and I was married at the time of my death. If I had no will and I passed away, Florida law would say that my spouse would get 100% of the assets that I own at the time of my death. And I can go through many different examples, but just to kind of stick to the point here, when after someone passes away, obviously we have the assets. How do we transfer these assets to the heirs or someone that inherits something under the law? If that person that died has a will, or the fancy name is the last will and testament, then the person or people inheriting those assets are called beneficiaries. So the distinction between an heir and a beneficiary, an heir is someone that inherits something through the law because someone passed away and the person that passed away didn't have a will saying where their assets go to. So some part in Florida law says, okay, depending on who's alive in this order, this person inherits something. And so that person would be an heir. A beneficiary is someone that's designated to receive something or receive an asset, maybe a car, some money, whatever it is, through the decedent, the person that died, their last will and testament. So if I drafted a will before I passed away and I nominated Sherwin to be my beneficiary or to get my Lamborghini, I don't have a Lamborghini, but if I did, I would leave to Sherwin. Sherwin would be a beneficiary, not an heir, because he was specifically named as a beneficiary in my last will and testament before I died. So if we go back to the probate situation, remember, this is it's almost a court case, but for someone after they've passed away. And the judge essentially has to make a decision. Who was this person survived by? Was there a will? Was there no will? And if there was no will, who inherits what? Did Giovanni have a spouse? Did he have children? Did he have are his parents still living? Did he have any children from a prior relationship? And maybe he has other children with a current spouse. So there's a lot of different ways it can go, and I can get into that towards the end. But the judge has to make the determination of, okay, who gets what? What assets do we have? And who essentially is going to inherit all of these assets? And the downside to probate is it takes time. Probate is not something that gets done in a day or two. A lot of times probates can take anywhere from 6 months, possibly to a year, depending on how many assets that person had, depending on whether there was a last will and testament or not. And sometimes you have people in the family that contest certain things. Just because there's a will doesn't mean that everything automatically goes to that beneficiary. You may have someone in the family that says, hey, my uncle Giovanni told me I was getting the Lamborghini, not Sherwin. Sherwin's not even a part of the family. Why would he leave the Lamborghini to Sherwin and not his family? So there's a lot of things that can go wrong in probate. You could have family members come from the woodwork saying, oh, and then maybe they introduce a copy of a will that they say was valid, or they say that Giovanni promised to give me this or to give me this pistol or this firearm or whatever it is. So just because when you have multiple parties involved, lots of things can go wrong. The second worst part about probate is it's expensive. Your family or your estate is going to have to spend thousands and thousands and thousands of dollars on attorney's fees to hire an attorney to handle the probate and court costs. Just when you have to file something with the court will charge the estate probably on average $400 just to file the probate with the court. And attorney's fees could range anywhere from $3,000 to $10,000. Sometimes, depending on the value of the estate, attorneys are entitled to take a certain percentage of what the estate is worth. So if you have a multi-million-dollar estate, you may have an attorney that goes in there and takes $30,000-$40,000 from the estate, and that's all money that otherwise could have went to your family, your children or your spouse or your friend, whoever it is that you wanted it to. And the last downside to probate is it opens up the door to potential creditors. So when you file a probate with the court, let's say, for example, and we're using me, unfortunately, I pass away and my probate's going on, my family now has to go and hire an attorney. They spent $5,000 on attorney's fees. They spent hundreds of dollars on court costs. They're waiting. They're 6 months in before they can even get their hands on any of my assets because they have to wait for the probate to be done. Meanwhile, I've passed away. I was, let's say, maybe a main source of income. Now my family's struggling. They have to deal with the grief of my passing. They don't have access to any of my money or anything that I left to them, and they have to wait for this probate to be finished. Now, let's say if I had certain creditors, maybe I owed $10,000 in credit card debt. Discover can file a claim against my estate in the probate case with the judge saying, hey, judge, look, before Giovanni passed away, he owed us $10,000 or had $10,000 owed on a credit card. And that would be a claim of a creditor. And so there's lots of different creditors out there, but let's say someone had a lot of debts, all of those creditors can file claims against the estate. And when they file a claim against the estate, they say, hey, look, we were owed this money. And the creditor can actually attach that claim to your money or your assets, and they can basically, chunk or kind of attack at your assets and what you had. So let's say we have a probate, and maybe the only asset of the estate was one bank account that had $20,000 on it. And I pass away and I have two children. And I didn't have a will. And under the laws of intestate, after I pass away, everything goes to my two kids in 50-50 shares. And $20,000 is the only thing that's in my probate. $5,000 of that probably got wasted on attorney's fees and court costs. Now we're down to 15,000. Let's say I owed that $10,000 on a credit card, and maybe now that credit card company files a claim against my estate. Guess what? Before the probate can be finished and before my children can receive their asset or the money that was in this account, they now have to pay off this creditor before they can get access to the money or the assets. So if we're at 20,000, let's throw $5,000 on the side for attorney's fees and costs. Now we have to pay off this creditor. That's another 10,000. And then maybe by the time the probate's done, after 6 months, now my kids are walking away with 5,000 bucks instead of the 20,000 that I worked very hard for. And so probate is not fun. After someone passes away, the last thing that you want your family or friends to be doing is to now have to kind of pause the grieving period and continue to kind of relive everything. They have to go see a probate attorney. They have to spend money. They have to spend money up front to pay for these things. They have to look for assets and account numbers and amounts that are in banks. And a lot of times after someone's passed away, a bank or a retirement account, or if you have certain insurance policies, they won't provide information to your kids or to your family members. A lot of times they'll say, hey, look, we need some type of court order authorizing us to release this information to you. So probate can get really, really messy. Again, you may have to pay off creditors. It's going to be thousands on attorney's fees and costs. It can take a long time, and it can get contested from other family members or friends. So one of our main goals here tonight that I want everyone to leave this webinar from is to say, okay, I see probate's terrible. How can I structure all my assets without my estate having to go through probate? How can I have all my assets that I worked very hard for, my entire life? How can I have those assets go directly to a certain person or multiple people that I want those assets to go to? And how can I avoid probate in between? And so the first and easiest step to avoid probate, and I think Sherwin had posted this on the Les Win Financial page, is you want to designate beneficiaries on your accounts. I'm going to elaborate on that a little bit. So if there's anything that you want to write down tonight, this is probably the easiest thing you can do because it's free. You don't need an attorney to do it, and it can take maybe 10 minutes to do. So when you designate a beneficiary on, let's say, a bank account, let's start with the bank accounts. If we go back to that probate example, I have a bank account with $20,000 on it. And obviously we saw what happens if I pass away and there's no will and there's no beneficiaries on this account, it has to go through probate. What I could have done differently before I passed away is designated my two children as beneficiaries on the account. And designating someone as a beneficiary on the account is just a fancy way of saying, hey, look, if I die, I want this asset or whatever money's in this account to go directly to this beneficiary. And it could be one beneficiary, it could be 1,000 beneficiaries, it doesn't matter. And it could be anybody. It doesn't have to be your kids, it doesn't have to be your spouse, it could be a friend, it could be a coworker. It doesn't matter who the beneficiary is. It doesn't matter if you have 10 beneficiaries or one beneficiary. As long as you have at least one beneficiary designated on that bank account, upon your death, those funds will go automatically like that directly to the beneficiary, and that account or that asset doesn't have to go through the probate process. And all you would have to do is you go to your bank, Wells Fargo, TD Bank, whatever it is. You can talk to the bank teller and say, hey, look, I'd like to designate a beneficiary on my checkings account or my savings account. We'll give you a form. You fill out the form. It's usually 1 or 2 pages. You just list who it is that you want to be a beneficiary. And again, you could put one beneficiary, you could put two. It doesn't matter how many, and it doesn't matter who it is. You'll put their name, their address, I think a phone number, maybe your relationship, and that's it. You give that back to the bank and you're done. So, God forbid, if something terrible happens and you pass away, whether you have $1,000 in that account or $100 million in that account will not have to go through probate. And automatically, upon your death, whoever is designated as the beneficiary will automatically be entitled to those funds. So the beneficiary would just go to the bank and say, hey, look, I was Giovanni's son. Here's a copy of his death certificate. I was a named beneficiary. At that point, the beneficiary, they can either withdraw those funds, they can reinvest the funds, they can move the funds. The beneficiary essentially steps into the place of the former owner. And essentially, they are pretty much the owner of the account and they can do with the funds what they want. I see a question here. Great question. Is payable of death the same as designating a beneficiary? Yes. It's sometimes you'll hear it POD or payable upon death. That's the same thing. So beneficiary or payable upon death, those are synonyms for each other, but it's the same concept. So if you went to your bank and said, hey, I would like to put a payable upon death on my account, the bank should understand. And that's the same thing as designating a beneficiary on the account. So remember, that's a bank account. That's the easiest way to do it. If we take that same concept with the bank account and we look at other assets, for example, maybe I have a life insurance policy. Maybe I have a 401k. Maybe I have stocks or bonds, or maybe I have an IRA, a Roth, whatever it is. The same concept. All you have to do is notify that company that you would like to designate a beneficiary or payable upon death. They'll usually send you a form or whatever's required. That's not difficult. You fill that out, you designate a beneficiary, and that's it. By doing that, it's free, and those accounts will not have to go through probate. That's the easiest and best advice I can give you tonight, and I'd recommend you do it as soon as you possibly can, just to protect yourself and to protect your assets. Does anyone have any questions about the beneficiary designations?
I have a question.
Yes.
It's not about the beneficiary thing, but do life insurance payments, are those affected also by creditors and everything if you have a life insurance policy for your children and stuff?
And that's a great question. So one of the benefits of not having to do a probate for your estate, guess what? When you do a probate, you're kind of opening up the door. Hey, creditors, I got a probate here, come and file your claims against my assets. But if a probate is not needed with the court, those creditors can't attach those claims automatically to your assets. They would have to sue the estate. If an estate is never opened up in the court, they're kind of in trouble there in terms of trying to recoup the money. So if you had a beneficiary in your life insurance policy, and let's say that's the only asset, and maybe it was a spouse or a child, and maybe you owe $20,000 on a credit card, the creditor, they can file a claim with the court saying, hey, look, Giovanni ever opens up a probate for his estate, then we want to enforce his creditor claim. But if a probate's never opened up, they have no way of enforcing that claim or to seek that recovery of that money against your assets, your life insurance policy included. So one of the benefits of also not having to do a probate for someone's administration is you're eliminating creditors' ability to go after your assets. Now, that doesn't apply to every creditor. That's like credit card debt, certain unsecured debts. A secured debt would be like a mortgage on the house. So you borrow money to buy a house. You usually sign a promissory note to the lender saying, hey, look, I promise to pay back $500,000 that the lender gave to me to buy the house. The mortgage is a document that's pretty much acts as collateral against the property. And so if for some reason you've stopped paying your mortgage or you stop paying your lender, the bank, then they can foreclose against the house, which means they can force the sale of the house to recoup their funds. But the mortgage is pretty much, it's recorded against the property, and it's what's called a secured debt. So you can't screw over the bank that gave you the money. Like if you go to sell the house, you got to pay them off. If you stop paying, then you still have to kind of pay them back or you lose the house. So if you had a question, for example, hey, if I restructure title on my house or I put a beneficiary on title, and it automatically goes to, let's say, my children. Can the bank that gave me the money to buy the house, can they then file a claim against my estate, or sue the new owners? That would be different because the mortgage sticks to the property. So it doesn't matter who owns it. If it goes from my estate to my kids, that mortgage is going to stay on the house regardless, and will still have to be paid by the estate at some point. So when I tell you that creditors are prevented from filing claims against the estate, it's not every type of creditor, but general stuff like maybe you had a hospital bill, dentist bill, credit card debt, things of that nature. That's the type of debt that wouldn't be able to attach to your estate.
Oh, okay. Is there a time frame or a limit in which they can continue to file for these claims?
Yes, 2 years from the date of the person's death in Florida.
Okay.
So
All
let's
right.
say, for example, like these are my favorite probates to do. If someone provides me with a probate and the decedent, that's the name of the person that's passed away, if they passed away more than 2 years,
Mm-hmm.
2 year window from the date of death, the first day after that 2 year period, creditors cannot file claims against the estate. But let's say you had to do a probate for someone that maybe passed away a couple of years ago, again, more than 2 years ago, I would file a probate with the court, depending on if they had beneficiaries designated or not, if their assets had to go through probate. Creditors are barred from filing claims against someone's estate in Florida if it's been beyond 2 years from the date of death.
Okay.
That-
This is
That's
another question too with the and I promise it'll be it. I don't want to hog it all up.
Oh, that's okay.
Is
I like this. It's engaging.
is um is that like for like you gave an example of like your mortgage, right? Okay, as far as that's I understand that. So even things like because I'm also gonna tell my kids about this too. So would like a student loan be a part of that? Because I'm trying to make sure they don't have student loans. I want to educate them more on that too. But a student loan would also be considered something like in the category of a mortgage.
Not necessarily, because the student
Okay.
loan doesn't have, there's not a secondary document that the student loan attaches to. So the lender on that case, like let's say if they stop paying their student loans,
Hmm.
then eventually they would have to sue the person. They could sue the person saying, "Hey, look, you owe $100,000 on this loan." But as long as they didn't collateralize that loan with something, like if,
Hmm.
for example, if you take out a student loan, and let's say the lender said, "Hey, we'll give you 100,000, but we need some type of a surety. We need a personal guarantee, or we need to attach a mortgage to one of the properties you own," because what the lender wants to avoid is having to sue somebody, right? And let's say they sue someone in court, they win, they get a judgment against that person for $100,000. But let's say that person's unemployed, doesn't have any money, doesn't have any assets. The lender's kind of screwed because they can't really enforce that judgment against someone that's unliquid, where that person doesn't have any money, they don't have a job, they don't have assets. So that I think for most examples, I don't want to tell you every single student loan is like that. At least most the ones I did were not secured against anything. It was just meaning if I don't pay, then they can sue me for the amount that's not owed, but they can't force a sale of my house or force a sale of my car or anything else because I didn't secure that loan with something else, another one of my assets, saying, "Hey, look, if I don't pay, you take my car. If I don't pay, you take my house." I
Or you
didn't.
mean like collateral? Okay. All right.
Right, right. So most of the time, and again, I don't want to say every student loan because every circumstance is different. Every lender is different. It's an agreement between the student and the lender. So don't take my word on this and say, "Hey, every single student loan is unsecured," because it could vary. But I think in my experience, what I'm seeing, most student loans are unsecured. So again, they can still sue. They still have a claim. You still owe that money, but that would be something similar to almost like credit card debt, where it's an unsecured debt. There's nothing used as collateral to basically say, "Hey, look, you failed to pay me. Now I get to take your car, or I get to take your ATV in the backyard." Something that allows them to get some type of consideration if you default on that.
Yeah. So, Giovanni, I believe we did have a hand up from
Yes.
Mallory Roger. Did you still have a question? If not, I do have a question as a follow on to this here.
Sure.
Yes, I do have a question. So in the situation pertaining to the house, so I have two minors. So are you saying that if I still have a mortgage, I still own the house, more than likely they'll be forced to sell the house, or how would they proceed? Or for me to have my mom or their dad guide them, like what would need to happen having a mortgage on the house?
And is this under the assumption that you're the owner and then you've passed away and the house then gets transferred to your kids who are
Right,
under 18? Are you asking
right,
who's in force or who's in charge of paying the mortgage and kind of staying on top of that?
right.
Good question. So that almost segues to our next subject. This is what I love when we have good questions that kind of take me to my next subject. So for instances like that, when you have children that are under 18 and in Florida, in order to be of legal age to sign legal documents, contracts, etc., someone has or a person has to be 18 years old. So that begs the question, if you're the owner of the property, let's say it's just you on title, and you pass away, and maybe you had structured title, and I'll go into this in more detail, but let's say you structured title and designated your two children as beneficiaries on title, or maybe you had a last will and testament, and maybe you were just on title to the house and had to go through probate. In any event, let's say your two kids inherit title to the property. Obviously, if there's a mortgage on there, those payments still have to be made. Just because the borrower passes away doesn't put a pause on those payments. The payments still have to go through. So now we have a dilemma where you have, let's just say your children are 4 and 5 years old. How is a 4-year-old and a 5-year-old going to pay a mortgage, right? So the trust or a trust is a document that allows you to basically control or restrict or direct somebody else to manage your assets after you've passed away. Trusts are very important because when you place an asset into a trust, it does not have to go through probate. And then you probably want to write this one down. This is important. So another exception to avoiding probate or having an asset having to go through probate is by transferring it into a trust. So if you have a house that's in a trust, it does not have to go through probate. So in this example, so Mallory, what I would suggest is that if you were to create a trust, for example, the trust would say, look, Mallory, I'm the owner of this property, these other assets. I have two children, ages 3 and 4. And you can put in there, hey, if I pass away, I nominate, let's say, I nominate Sherwin Riley to be what's called the successor trustee. A successor trustee in a trust is pretty much someone, or it can be multiple people, that are nominated by the person that creates the trust to essentially manage and maintain the trust and the trust assets for the benefit of the beneficiaries. The beneficiaries are essentially the party or the person or parties who the trust is being created for. So in this case, your two kids would be the beneficiaries, but obviously they can't sign legal documents, they can't pay a mortgage, they can't do all that. So in the trust, you can put language in there which nominates Sherwin which essentially says, hey, look, if I pass away before my kids turn 18, I want Sherwin to be the successor trustee and manage the trust and the trust assets until my kids turn 18. Once my kids turn 18, they can inherit the assets. They can take the house. They can do whatever they want with the house. But until then, Sherwin would be in charge of basically making mortgage payments on that house. And where would he get the money? If you had all of your assets or money in the trust itself, Sherwin, as the trustee, as the successor trustee, would have the legal authority to basically take money from the trust and pay the mortgage. Now, if
So
there's
life
other,
insurance, my life insurance could be in the trust as well, or
yes, yes. So what you can do, remember the beneficiary concept that we were talking about?
right.
You can designate your trust as the beneficiary on your assets. And that's what I like. That's what I recommend to most of my clients. So if you have a bank account, let's say, whatever is in there, you have a life insurance policy, and let's say you have a 401k, you can designate the trust as a beneficiary on all those assets. So that way, in the event that you pass, everything that you have automatically and in a clean way transfers to the trust, doesn't have to go through probate. And now your trust or the language in the trust will say, hey, look, whatever's in here, this is how the money is going to be spent. Whether it's the money in the life insurance policy, your bank account. But I like having everything flow into the trust because you have one document, essentially, which is the trust, that tells the successor trustee, this is what you're supposed to do with the money and the assets in the trust. And so in your question, what you could do, you would put in the trust that Sherwin is to act as a successor trustee until your children turn 18. And you can say Sherwin is to use the money from my life insurance policy to pay the mortgage on the house each month until my kids turn 18. Once my kids turn 18 or 21 or 25, whatever it is that you want to put in there, or maybe they graduate from college, you can put restrictions on there,
Yeah.
but
Right.
whatever it is, whatever that condition is that you want to put in there, Sherwin or whoever the person is, or multiple people that are the successor trustees, they pretty much manage your assets after you've passed away for the benefit of the beneficiaries. And so you can also put language in there too, which says if my kids need money for let's say school tuition or food or clothing or dental insurance, whatever it is, you can give the successor trustee the authority and their discretion to use money for certain things for the benefit of the kids. So a lot of times, in my trust that I draft, I'll say that the successor trustee has the legal authority under his or her own discretion to use money for clothing for the children, food, shelter, whatever it is. And so that way, it essentially allows someone to manage all of your assets for children or whoever it is that's the beneficiary. And then you can also put in the trust too, you can also nominate a legal guardian. The legal guardian would be someone that essentially becomes the new parent, kind of the children until they reach age 18. And the legal
Okay.
guardian has authority or legal authority to sign legal documents and make decisions on behalf of the minors until they turn 18 years old. So let's say, for example, your kids are now the owners of this house, right? Or the trust is the owner of the house. And maybe you want to sign a contract on behalf of the beneficiaries of the kids. The legal guardian of the kids would have the authority to kind of sign on their behalf or to open up a bank account, in their name or whatever it is.
So the house will be in the trust. I will have the funds from the life insurance paid until they reach a certain age or they graduate or they have jobs. Then the house will then belong to them, or is stuck to the trust, or can they now claim it?
It belongs to the trust so in the trust, you would put language essentially saying that upon my kid's 21st birthday or whatever it is, all assets of the trust will be distributed and transferred to my two children in 50-50
Okay, nice.
shares. And basically once the final distribution is made over an asset or multiple assets, at that point the trust will terminate because the trust has served its purpose essentially.
Oh, nice. So a trust is way better than a will then.
Oh yeah, a will is a waste of time. Well, let me not
10 times.
let me change my words. I don't. So a will is good because let's say you have beneficiaries on all your accounts. You have your property in a trust. You watched your estate planning seminar tonight, and you say, "All right, I'm good. I don't need to do a will because I have beneficiaries on all my accounts, on my bank accounts. I put my property in a trust, or I restructure title to add someone else on title." Long story short, all of your assets are structured correctly so it doesn't have to go through probate. The only benefit of a will would be it kind of acts as a safety net. So let's say all of your assets are structured where you have beneficiaries on there, they're in a trust. And let's say you win the lottery the day after that, you get $1 million and you go to the bank, you open up a new bank account, you cash the check, there's $1 million in there, and you forgot to designate a beneficiary on the account. And then you walk out of the bank, you get hit by a bus, and now we have $1 million sitting in the bank account. So the will, it would be a little convenient in the sense of if a probate is needed for a particular asset, or if it does have to go through probate court, the will at least says, hey, look, whatever goes through probate, this is where I want my assets to go to. I want it to go to my two kids or my spouse or my friend Sherwin or whatever it is. So will, it can be effective if an asset has to go through probate, because rather than the asset being distributed to the person under the Florida law, if there is no will, sometimes it'll go to the person you want to under Florida law. But other times you may say, you know what, my family's been mooching off me my whole life. I pay for their expensive dinners. I've taken care of them. I want my best friend John to take whatever's in my estate because I've helped my family out. Barring a will, if you don't have a will in place, then it would go to whoever's next in line under Florida law. So the will can be beneficial if a probate was needed, and that it will designate who the beneficiary or beneficiaries are.
So,
But
attorney,
you don't need a will, though. If you do
yeah.
everything right, you shouldn't need a will.
Yeah. So, attorney Borges, this is very, very, very great information here. Let's just answer some of those sidebar questions that came with it. And you don't really have to go like too in detail with it. But Malcolm here, they're based in they're based in the Virginia area. He said, what's the best way to establish a trust? I know you're in Florida, so maybe you could speak to how that works and answer this question here.
Sure. So a trust doesn't have to be 100 pages, doesn't have to be 20 pages. It just has to have certain elements. Now, if you're in Virginia, I can't tell you what the legal requirements are in Virginia, but in Florida, the general rule is that it has to be signed by what's called the settlor. The settlor is the person that creates the trust. You have to nominate a trustee who can make the decisions on behalf of the trust and beneficiaries. In Florida, there has to be 2 witnesses and a notary to make it effective, and that's it. Now, you don't need an attorney to make a trust. You don't need to go and spend money and hire an attorney. If you find a form online that you like and you think is sufficient, you can do that. So you're not required to have an attorney prepare it. Although, me as an attorney, I would always recommend that you do have an attorney that practices this type of law prepare the trust for you. Obviously, it's going to be some type of money, but you never want to go cheap on these things. You want to make sure it's done correctly, and the attorney, especially if it's in a different state, they can tell you do's and don'ts and exceptions under the law and answer any questions. So again, I'd recommend consulting with an estate planning attorney that's located in your state. They can help you with that trust. But if you want to go that route and you want to draft something on your own, you can definitely do that. But I'd recommend consulting with an attorney that practices in estate planning in your state.
All right. Then the next question here says, my mother and I are joint owners of the family home. Can I put my portion in a trust so it can go to my daughter, or will it all have to go to my mother?
Yes, great question. And you can. So it depends on what type of ownership it is. You might be on there as joint tenants with the right of survivorship, which means that if you have 2 people on title, if one person dies, the dead person's interest automatically goes to the person that's still alive. Or you might be on there as tenants in common. Tenants in common means you have 2 people on title, well, not 2, you have multiple people on title. And if one person dies, instead of their interest going to the other person that's an owner, their interest goes to their estate instead. So if it's you and your mom on title, then yes, you would be able to execute a quitclaim deed, transferring your 50% interest to your trust. And then your trust would essentially say what happens to your 50% interest. So yes, you can definitely do that. And you would just prepare a quitclaim deed, transferring it to the trust, and obviously have a trust in place.
Okay.
Oh, but I think she's asking, will it all go to her mother? It depends on the ownership. If you send me the address, or if you send me the property address after this, an email, I can look it up and tell you.
Both
But it
on the
depends
title.
on how the ownership is.
We're both on the title.
Does it say joint tenants with the right of survivorship on it? Like it has to have that language specifically.
Okay, that I don't know.
Yeah, if you have a copy of the deed, or if you just send me the address, I can look it up in 10 seconds and tell you.
Okay.
After the webinar.
Absolutely.
All right. So I think you pretty much hit up on the first question here that Julie asked, but let's just go here to the second one. Can you please speak on adding an LLC to a trust?
Yeah, so you can make an LLC the beneficiary in a trust. A trust is not limited to just people. You can involve entities as well. So if you wanted, like someone, an LLC to act as a trustee, you can definitely do that. Sometimes you'll even see that a bank will be nominated as the trustee of a trust. So let's say you wanted your LLC to act as the trustee of a trust, and that's the trustee is the person or entity that makes decisions on behalf of the trust and has a legal authority to sign documents on behalf of the trust. And so in this case, yeah, you could put your LLC as a trustee of the trust. You can put the LLC as a beneficiary of the trust, basically saying, hey, look, and whenever this trust is terminated or after 2 years, whatever it is that you want to put in there, you can have the LLC act as the beneficiary in the trust.
Hey, Giovanni, I want to also express this here to the community because I speak about this a lot, especially like with homeowners, like for them to really know, like, and maybe you can harp on this a little bit more. If they do own a home and they only have a will, and let's say, for instance, you got a husband and a wife and they have a child per se, right? And they only have a will. The house is going to go to probate.
Yes, depending on how title is structured, and if they both pass away, then yes, in order for it to be transferred to the child, that will just says, yeah, it goes to the kid, but a probate would be needed.
Yeah. So that's a big thing I try to harp in the community, just letting people know that if they are homeowners, in order to avoid probate, please put a trust in place to avoid basically what you've been talking about as far as the issues that comes with a probate in itself. Um, so if you guys are hearing it, not just my voice, but straight from the estate planning attorney, if you own a home, if you have a will only in place, you're going to go through probate. So putting the trust in place is very, very important in itself. All right. So Kalar has a question as well. Can student loans, I think we kind of addressed this before, but maybe just quickly here. Can student loans sue the trust?
Not really. The lender is kind of bound by whoever the borrower is. So if it's Wells Fargo, let's just say, is the lender and I'm the borrower, they can only sue me because I'm the party that signed that contract. So the contract, you have to look at the four corners of the contract. The only two parties in that contract are me and the lender. So they would only be able to sue me, not my trust.
So Giovanni, let me ask you a question here. So you set up my family trust, and so we have it set up to, in the event when Leslie and I expire, we have a successor since our boys are minors. Let's say, for instance, when the boys do get to the point where they can start accessing those assets, right? Let's say, for instance, they get married, right? How can we actually avoid, let's say for instance they get married and say 3 years later they get a divorce, and now that spouse is entitled to half of what mom and dad has worked so hard for. Is there any language that we could put in our trust, or maybe amend it to even go beyond and put some specifics in that to protect them?
Yeah, I get that question so often. I always get parents come in and they say, "Hey, look, we love our daughter-in-law or our son-in-law, but respectfully, we don't want them to get a penny." And I said, "Look, there's nothing wrong with that. It may be a part of the family, but you want your kids to get what you've worked hard for. You don't want someone else taking half of that or alimony and everything else." So, generally speaking, if you have a trust in place and you have your children listed as beneficiaries, you can specify in there that whatever it is that they receive is strict. I mean, you got to just really just add some language in there just to specify what the intention is and say that the amount is to be used strictly or it's strictly for the benefit of whatever your child's name is and to no one else. And now if that money gets dispersed to your son and then your son puts it in his account and then your son cuts a check and gives it to his spouse, and we can't
Yeah.
really reach that far and restrict him from doing so. But what I would recommend is, and you have to tell your children this, is that if they get married, commingling of funds is the worst thing you can do, because once you commingle funds, it becomes what's called a marital asset. And then if a divorce happens or a dissolution of marriage happens, generally speaking, we have equitable distribution, which is the fancy way of saying whatever it is that the married couple owns, the assets usually get split in some division, 50-50, 60-40, whatever happens in the divorce. But the marital assets usually are the only assets that fall under that. So if you have money in your own bank account where there's no commingling of any type of marital funds, your spouse isn't on that account, they're not joint, they're not a beneficiary, they don't have any access to that. It's just money you kind of maybe keep to the side. Generally speaking, that's not attackable by the other spouse in the divorce case. But again, there's lots of things, that's more of like a family law question that can go a lot of different directions. But
Right.
most part of your trust, you just kind of want to put specific language that says, my son is married, but this is strictly for the benefit of my son and not for the benefit of any other party, including his spouse. Sounds a little mean, but there's nothing wrong with putting that in there.
Yeah. um, so one question here says, what about using LegalZoom for a trust?
Yeah, I'm not sure. I know LegalZoom is like a third party service. I think this question is just like if you go to hire any type of person in any profession, whether you're going to a car dealership or whatever it is. I think you just have to do your own research, look up Google reviews, look up social media pages, and just do what you can to try to find reviews. Lawyers, it's just like any other profession. There's great lawyers and then there's crappy lawyers, and in any other profession you have good CPAs, bad CPAs. So in terms of anything specific, I think what you want to focus on is that the lawyer focuses on estate planning or wills and trust. You wouldn't want to go to a lawyer where you look at their website and it says that they do slip and fall and personal injury. That doesn't mean that they can't do estate planning, but you want to try to focus towards an attorney that focuses on that type of law of what you're looking for, like estate planning, wills, trust, probates. That's what you want to look for. Legal Zoom,
So
I'm not sure.
yeah, and also too, Patron, that answers your question as well. But Attorney Borges, just for a few more minutes here, also within a trust and what it contains, if you could speak to if you're incapacitated, right, the benefits when it comes to a trust in those regards, to signing documents or medical attention.
Yes, so the benefit of the trust as well is you can include language in there which says, while I'm alive, obviously I'm the owner or the settlor of the trust. I'm the trustee. I'm the one that, since it's my trust, my property, when I'm alive, I can sign these things. And again, usually a trust is really meant more so after you've passed away for someone to manage your assets. But in the event you become incapacitated, which is a fancy word of saying you're legally not competent. Maybe you're in a bad car accident, you're in the hospital, you're not of sound mind, you're unconscious. Maybe you're in a coma, or just whatever it is, you're not physically able to sign documents or make decisions on your behalf. You can include language in there which has the successor trustee, Sherwin in this case, based off of I think Mallory's example. You can have someone else, or you can give them the authority as maybe a co-trustee, or you can restructure language, but you can give someone else authority to sign on behalf of the trust if you're incapable of doing so. Outside of the trust, there's another document called a power of attorney. Some of you may have heard that before, but a power of attorney essentially does what I just mentioned in the trust. So power of attorney is something separate from the trust. It's a different document, but it allows one person or other people to sign legal documents on your behalf if you're unable to do so. Now, you have to be careful with power of attorneys because you're giving that person or those people a lot of power, to sign on your behalf. So you don't want to give a power of attorney or nominate someone to be your power of attorney that you don't have a good and trusting relationship with, because in that case, if you give them authority to sign on your behalf, and let's say you're incapacitated or you're not doing well and they have authority to sign on your behalf, they could sell your house, they could sell your car, they could wipe out money from your bank account. So with power of attorneys, you want to be very cautious in terms of who you're giving that authority to.
Can I ask one? Well, I have two more questions, and that's it. Is what if you want someone? Is it possible to have a trust for someone who doesn't even live in the country? Like they can be in the trust also. Do you trust to disperse things themselves if they don't even live in the country? Because I have family that lives in London and Africa too, and if I pick one of them to be in that trust, would that be taken care of also?
To be in the trust in what capacity?
As far as looking over things or signing things in my state.
You could.
In my yeah, okay.
Good. I think, and it kind of relates to the power of attorney. Like if you wanted one of your family members in London to have power of attorney over you, you could. It just might be a little inconvenient. And sometimes if you have like legal issues or like you're going to sell a house, an underwriter who's insuring the transaction, they may not be super comfortable with someone from London signing like closing documents for your house here in Florida. So I don't think there's anything that prevents that. But ideally, if you can have someone that's in state or even maybe in the country, that would be a little more beneficial.
What about receiving anything?
If they're not receiving anything?
No, if they are receiving anything. What if I said, you know what, I want my brother in London or in London to get the house? Is that possible? He was born here, but what if I want that to happen? Could something like that happen? Okay.
Yeah, you can do that.
All right then. And another thing with the trust too, are there if I have certain criteria to be met before anybody gets anything, can that be also, the language can also reflect that in the trust also?
Yes. A lot of times you'll see like TV shows and movies where you have a wealthy billionaire that's passed away and the kids are just snobs, and they don't do anything. And they think that, okay, the person's finally dead. Now they walk into, millions. So you can put restrictions in the trust of, for example, I did one for a gentleman that served in the Marines, and he wanted his son to serve 4 years in some type of military branch. And so he put that once his son completes it was like an active contract or 4 years or whatever the appropriate duration is, that upon him completing his term with the military, whichever branch it is that he chose, he would then be eligible to receive whatever was in the trust. And if you want to put something else in there, my kid has to graduate from Harvard Law School, I wouldn't recommend that. But yes, you can put restrictions to kind of motivate your beneficiaries. So rather than them walking into all your money and you want them to kind of work hard or do something, and on a more serious subject, sometimes I've done some where a parent had concerns that one of their children had an alcohol issue or a gambling issue, and they knew that if they passed away and all the money went to their child, that the child would blow it all on drugs in one night or gambling. You can restrict it too and say that the successor trustee is to distribute $100 to the beneficiary every month. Or if the successor trustee sees that John Smith has been sober for 1 year, he's eligible to receive 20% of whatever's in the trust. So you can get very creative with how the distributions are made. I mean, I don't want to say there's nothing you can't put in there, but you can get very creative with the restrictions that you put on there.
All right, we'll take just 2 more questions here. Mallory, take one from you, and then we'll take one more from someone else, and then we will have Attorney Borges share his contact information, and you guys will definitely be able to reach out to him as he's been able to assist the community with several trusts. But go ahead, Mallory.
Do you recommend that as soon as the children turn 18 to have them included on the deed of the house, and that will avoid so many issues if we were to not go the trust route?
Yes, so you don't have to put a property in the trust. I think this is one good subject to kind of cover on the back end here. So if you're the only owner on the property, and let's say your children are above 18 or family members, whoever it is that you want to add title, think about it like a bank account. Obviously, you can have a beneficiary set up, but you can also have someone joint on the bank account. A lot of times, married couples will be joint on a bank account, which means any person can take any funds at any time. That's also an exception to probate. I forgot to mention, if you have multiple people that are joint on a bank account, then that account doesn't have to go through probate if one of them pass away. Vice versa, it's the same thing with property. So let's say if you had 2 of your children on title as co-owners per se, and they're all over 18, then there's no issues there. If you structure title the correct way, and there's more, that's a topic for another day, but if you have title structured correctly and you have them as co-owners on the property, you wouldn't need a trust. Because if you passed away and the language in the deed is structured correctly, they would become the new owners, and then eventually would essentially be the last person standing, no pun intended, become the next owner at that point. Now, if there's a person on title, you want to look out for that, because if that person dies, then it has to go through probate to transfer to whoever it is that's in the estate if the property is not in a trust.
Yeah, because right now I'm the only person on title, but my daughters are 14 and 16. I'm waiting for them to turn 18 so I can add them. But in the meantime, I don't know if I should just go ahead and do the trust, because you never know what can happen. 2 years is a long time. And so I'm thinking I can do trust. And can I word in the trust that once they turn 18, I'm adding them to the deed? So then that's when the trust would be terminated.
Yes,
for that house, that property.
Yes, you could advise the successor trustee to sign a deed transferring title of the property from the trust to them in their individual capacities. You could do that.
Right.
In your situation, I would recommend a trust. I can tell you that whatever you're going to spend on creating the trust and the deed is going to be significantly less than how much a probate would be if you didn't add them on. If you didn't put it into a trust, whatever they would have to pay for a probate with attorney's fees and costs would be significantly more expensive than whatever you would pay for a trust and deed.
I agree. I'll be calling you. Thank you.
No problem.
All right, we'll take one more question here. One more question. So I'm assuming everybody have their estate plans in order. One more question here. Okay.
I ain't got a question, but I appreciate the information.
Oh, absolutely. Hey, Attorney Borges, so do you mind sharing with the community here, and for the ones that's be watching the replay as we'll be sending this out to the community, how can they get in contact with you to set up their estate plans?
Yes, I'm going to type my business information here in the chat. And if for some reason, if you guys can't locate it, if you Google my name, just Giovanni V. Borges, you'll see the law firm information come up. It has the phone number and my email address. You'll see the website, but I'm putting the office phone number here. And if you do call, we get lots of calls all the time. Just mention that you attended the webinar or you came from Sherwin, and then I'll make sure the call gets to me, because a lot of times we get just random calls, and sometimes it's tough, hearing and depositions. But if you just mention that you attended the webinar, they'll make sure that the call gets directed to me.
Yeah.
I put the
And
office.
so, Attorney Borges, while you put that information, I got to tell the community this here. There was another member in the community. She got her trust done, but she shared a unique story with me because she found out when she contacted Attorney Borges that he was in her same neighborhood. So she got the trust done right at her house. So it was very special for her to do that. So she's getting ready to retire, and she has, I forget how many kids she had, but she wanted to make sure that she had her affairs in place so her kids wouldn't necessarily be arguing. So she got that done in herself. So I was like, wow, she told me that story because I hear so many people like just getting their trust done through you. And I'm like, wow, that was a very unique one, but very good in itself.
That's because she lived 30 seconds away. If you guys live an hour away, I'm not driving to you. that was, she lived really close. I was able to walk there, but yeah, you guys can always come to my office, or we can always meet somewhere halfway. And I always try to work with everyone. I know sometimes during the week it's difficult to come to the office or to arrange things. So if we ever need to sign documents on the weekend, we can always work something out where we'll meet somewhere at an office, or to have the documents signed. But yeah, I do probates, wills, trust, obviously. Just do general civil litigation, real estate matter, title, a little bit of everything there. But like I said, hopefully you guys enjoyed the information tonight. I know it's not super exciting, but I'm proud of everyone for attending tonight, because you're investing in yourself, you're investing in your education, and that's the best thing you can do. And this is important stuff. It may not seem important now, but when that time comes in the future, and it's going to come for all of us, unfortunately, what you want to do is you want to make sure that your estate planning is in order. And I guarantee you, once you have all of this done, you're going to be able to sleep a little better at night, knowing, God forbid, if something terrible happens, your family, your friends are protected, and they don't have to go hire an attorney like me and waste thousands of dollars. And you worked hard for your assets, your money. You want to make sure that what you worked hard for goes to the people that you love, and that you want to inherit those things. So just come see me. I'd be happy to help.
So my question I put in earlier, because I'm in Texas, and there's a whole lot of lawyers in Texas. I know you said someone who has certain skill sets or what have you, but is there a site or something that you can recommend that we can go on for people who are out of state, who to find credible attorneys?
I think there's a website called Legal Match. I
Mhm.
know that, I think, and again, I don't work with them. I can't tell you specifically. I know they contact me all the time because they say that, hey, we have all these clients that are looking for estate planning attorneys. Are you interested in taking on their cases? And they kind of act like a referral network. So try Legal Match. Again, don't hold me to it. I'm not a part of their company. I don't have any association with them. That's the only third-party vendor that I know that might be able to assist. But I would try to maybe find someone local and just type in estate planning attorney, and then just call. Just ask to speak to the attorney. Most attorneys, I don't want to say all of them, will give you some type of free consultation, and just do a lot of listening. Just kind of vet them, and don't just settle with the first attorney that you talk to. It's okay to call the attorney, ask them questions, kind of gauge their knowledge. After all, you're paying them for a service which is very unique, and it probably won't be super cheap. So make a couple calls, try to vet the attorney, ask them certain questions, see who it is that you think is the most knowledgeable, and obviously can help you with whatever your situation is. And at the same time, it can be a little pricey depending on which attorney you go to. So just take your time, maybe do some research online, make some phone calls, ask to speak to the attorney directly, not the paralegal. Paralegal might be beneficial, but at the end of the day, you want to make sure that the attorney really knows what they're doing before you start doing all these documents and spend some money on it.
Right. Yeah, because some of over here in Texas are a little suspect. So
I think in every state you probably have
Yeah.
suspect attorneys. Unfortunately, it's a stained profession.
Absolutely. So, Attorney Borges, as well, for the ones that's here in Florida that may not be in particular South Florida, do you also offer access via Zoom as far as where they can set up meetings with you as well?
Yes. So you don't, like I said, you could be in North Florida. You don't need to come to my office. If you want to do a Zoom meeting, we can do that. Phone calls, emails, whatever it is that you prefer. And the way I usually work is we'll have an initial consult. We'll see what your goals are. I'll tell you what I recommend. I'll give you a quote, assuming we both want to move forward at that point. I'll draft a rough draft of the documents. I'll send you the rough draft. We'll do a Zoom. We'll review everything together. And then at that point, once we have the final version done, you can just take those documents, generally speaking, to your bank, or if you know people that can act as two witnesses and a notary, that's usually what you'll need. I'll tell you exactly where you need to sign and everyone else needs to sign. But usually if you go to your bank, as long as you have an account there, they'll have two people that can act as witnesses and someone that can act as a notary, and then we can get it done. And you would just send me pictures or copies of the documents, and that's it. So anywhere in the state of Florida, I can assist.
Absolutely. Now, Attorney Borges, I don't see your contact information here in the chat unless I'm just
I sent it as a direct message to Miss Jackson. I don't know how that happened.
oh, I see.
Oh, you know what? I think I had her thing highlighted. I was trying to react with a thumbs up to like one of the
Oh,
messages.
oh,
Let me
yeah.
let me resend it right here.
Yeah, no worries. While you do that, I'll just tell the community, thank you guys for joining in tonight. As you know, that this information here is very vital in itself, and so as he's putting this information in the chat, I would ask that you write it down, and if you also can contact me, I can provide you his contact information as well. But we work hard for our dollars, and the most important aspect here is to protect it. And so, it's nothing like just throwing money away. But then also too, when there's death in families, there's a lot of fights, there's arguments because financial affairs not in place in itself and protected. So this is a very important webinar. We're getting ready to go into the holidays, and so it's a great time to start having these discussions with family members and deciding, where assets may go to. That's something that we did in our family, and so I would recommend you do that in your families as well. Attorney Borges, any final comments here before we close out tonight?
I think for once I don't have too many words, which is great. My girlfriend's always happy to hear that because I usually talk too much. So hopefully everyone enjoyed the information tonight. I'll always be available. You have my email address there. And again, if you do call the office line, just mention that you attended the webinar or coming through Sherwin, and then we'll make sure that I speak to you, and I'd be happy to help. And I'm proud of everyone that attended tonight, not because it's just to hear me talk, but it's the step of you took an initiative to invest in yourself, invest in your education, invest in your money, your assets. You're looking out for your family and friends. So that's something that you should be proud of. Attending a webinar for an hour at 8 o'clock on a Thursday night, most people don't want to do. So you should be proud of yourself for investing in yourself and your education. It's important.
Absolutely. Thank you for again for joining us on an annual basis. It's always a pleasure having you and just breaking things down to a point where we can just understand it. So again, everyone, thank you guys for joining in to the state webinar session tonight. And this will end, and hope you guys have a great weekend, and we'll be talking soon. All right. Thanks again, Attorney Borges.
No problem. Good night.
All right.
Good night.